All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Thank you. You may be seated now. For the counsel in this case, you were so busy before oral arguments that you didn't have a chance to attend the reception that we had for all these summer law school interns here in Montgomery and even from Birmingham. So that's the audience that you have around you. Show them well how it's done. And I will tell you in advance that Justice Cook is not with us in person, but he's participating online. So if you hear a disembodied question, respond to it. And would the clerk please call the case for us?
Good morning, everybody. We're here to hear oral arguments in the case of SC-2022-0867, Luxottica of America Incorporated, Jeremiah Andrews Jr., and Anthony Pfleger versus Jackie Lee Bruce. Counsel for the appellant, are you ready to proceed? Counsel for the appellee, are you ready to proceed? Let's get started.
Is it pronounced McLeod or McLeod?
McLeod, Your Honor.
McLeod with a 2C sound. Okay, good. You may begin.
Mr. Chief Justice, and may it please the court, this appeal turns on one thing: whether Jackie Lee Bruce proved that Anthony Pfleger acted with actual malice in his statement to Crime Stoppers. Certainly, Your Honor, I apologize. Thank you for letting me know. To overcome a qualified privilege defense, a defamation plaintiff has to show actual malice, and for punitive damages, must show that by clear and convincing evidence. That burden lay on Bruce, and he failed to meet it here for three reasons. First, there is no evidence in this record of an ill will or a motive to do injury to the plaintiff on the part of Anthony Pfleger. Second, there's no evidence in this record of fabrication or falsehood by Pfleger. And finally, the Crime Stoppers post on its Facebook page cannot be evidence by itself of malice simply because of how many people enjoy Facebook. One of the ways that a defamation plaintiff can show malice, as this court stated in Wiggins, is, as I mentioned, with evidence of an intent, a desire, or a design to do harm to a plaintiff. There is nothing like that in this record on Pfleger's part. In fact, the undisputed evidence was he had never met Mr. Bruce. He did not know the man. There was no prior history, no hostility, no rivalry between them. In fact, the evidence was that everything Pfleger did in the aftermath of the shoplifting incidents was simply part of doing his job. He took an eyewitness statement from Jeremiah Andrews. He watched the security video footage for himself, and he reached out to law enforcement several times in an attempt to get the Montgomery Police Department to investigate, ultimately with little success. And only after these things, and on the suggestion of mall security, did he reach out at last to Crime Stoppers in an effort to get their help to identify unknown suspects. None of this evidence suggests that Anthony Pfleger bore Mr. Bruce an ill will or had a motive to do him harm, so this avenue of proving malice is closed to him. Another way that a defamation plaintiff can prove malice is with evidence of fabrication, of falsehood. In other words, evidence that Pfleger knew when he made his statement to Crime Stoppers that what he said about Bruce was false. Here again, though, Bruce comes up short because the only evidence he offered below was his own testimony, where he merely contradicted the appellant's evidence of what he did. That is to say, he took the stand and denied that he was there with the known thief, or that he was an accomplice to the thief, or was seen getting into the car with the thief afterward. But all of that testimony and evidence was simply by way of contradiction of the appellant's evidence. It was not suggestive or probative of falsehood. This court itself noted in the Willis case that showing a statement is untrue does not show that it is maliciously made. And we cited other cases in our briefs to demonstrate that evidence contradicting something that is offered does not show that it is malicious or fabricated. Bruce's testimony at trial concerned the accuracy of Pfleger's statement to Crime Stoppers, but it was not probative of Pfleger's honesty. It did not suggest that there was bad faith on Pfleger's part when he reached out to Crime Stoppers. And so this too, especially given that the qualified privilege defense only operates when a statement cannot be shown to be true, this avenue also is closed to Bruce to prove malice. Finally, Bruce sets much store by the Facebook post made by Crime Stoppers on its Facebook page and emphasizes repeatedly the number of people that were fans or members of the Crime Stoppers Facebook page, and indeed how many people at large presumably have access to Facebook. This court has noted that one way a plaintiff can show malice is what is called the, quote, mode and extent of publication. In other words, sometimes if a statement is published to an extent greater than is necessary in the circumstances, that can be suggestive of malice. But that begs the question, what is necessary? And the answer is found in a settled principle, which is the qualified privilege defense is commensurate in its scope with the legitimate interests or duty that gave rise to the privilege in the first. The defense is no more but no less broad than the interest that gives it life. We gave an example of how that operates in our briefs. On the one hand, you may have someone that needs to solicit public help to identify unknown suspects and solve a crime. On the other hand, you may have an employee at work who needs to report misbehavior by a coworker to his boss. In that latter instance, the privilege would only be broad enough to allow a statement to be made reporting the misbehavior, because that interest can be fully vindicated. You can vindicate the enforcement of employment policies by talking to your superior. That employee would not be justified in taking out a billboard ad or posting on Facebook to advertise to the world what his coworker has done. In the first instance, however, the very nature of the interest involved, the general, if not universal, public interest in solving and preventing crime, does justify a broad extent of publication. This court itself noted in Barnett versus Mobile County Personnel Board that even a statement to the general public can be shielded by qualified privilege. That settled rule of law is all the court need apply here. It may be true that social media is a relatively new phenomenon, the internet itself, but electronic communication by defamation defendants is not. Television and radio have been with us for decades, and it has long been true that a defamation defendant can make a statement about a plaintiff that might instantly reach millions upon millions of people worldwide. And yet, despite that having been true for quite some time, there is no rule of law in Alabama that allows a plaintiff to show malice sheerly by dint of a statement being made electronically to a potentially large audience. The only thing this court need do to address how the qualified privilege defense applies specifically here to social media posts or internet posts, which is, I grant you, apparently the first time this court will have addressed that question, is to apply in a straightforward fashion the established rule that the qualified privilege defense extends just as broadly as the interests or duty being served and the interests or duties that gave rise to the privilege in the first place.
Mr. McLeod, Mr. Bruce's counsel has made an argument that privilege does not apply with libel per se. Would you please address that argument?
Your Honor, if I understand your question correctly, I think you're referring to an argument by Mr. Bruce that the privilege defense somehow doesn't apply to a statement that's considered to be defamatory per se.
Yes, that's the argument that I want you to respond to.
Yes, Your Honor, and my response is that is not the law. The cases which we have cited in our briefs on qualified privilege, Nelson, Willis, among many others, I think Butler versus Town of Argo may have been one of the more recent cases, elucidate the qualified privilege defense, which presumes the statement to be false, but there is no limit on that defense as only operating when a statement is defamatory per quad, I think is the other species. There's no rule that I'm aware of, and no case that Mr. Bruce ever cited that I saw in his brief that held that the qualified privilege defense does not apply to a statement alleged or proven to be defamatory per se. So I'm simply not aware that that is a legal limitation recognized by this court on the defense, have never seen a case to so say, and did not see that cited with authority to support that in Mr. Bruce's brief.
Thank you.
The Sunglass Hut store here had been the subject of repeated shoplifting incidents in a narrow window of time. And when the known thief returned again to the store, this time he came apparently accompanied by Mr. Bruce. Now, everything that happened in that store thereafter, this court can see for itself in the security video footage, in the record, a copy of which was attached to Appellant's briefs. But Pfleger's response, his investigation in the aftermath, in his position, after all, as the investigations manager of the Asset Protection Department of Luxottica, his actions were reasonable. They were logical. They were compelled by his job responsibilities. And what he did in his investigation, including his statement to Crime Stoppers, those actions were undertaken not only in good faith pursuit of the duties he bore to his employer and his customers, but also in vindication of the compelling public interest in solving, investigating, and preventing crime. Appellants shouldn't be liable for that. And they urge this court to reverse the judgment below and render judgment in their favor. And unless any...
Mr. McLeod, this is Justice Cook. We don't get to the actual malice unless there's qualified immunity, right?
As a practical matter, Your Honor, that's correct. The qualified privilege defense operates when the defense of truth does not. That defense, the defense of truth, is not operative here, so qualified privilege has been asserted, and in that case, the way, if at all, that the plaintiff can overcome or get around the defense is by proving actual common law malice. And, as I mentioned earlier, for 75% of this judgment, which was punitive, the burden is on Mr. Bruce to prove malice, regardless of the qualified privilege defense, by clear and convincing evidence, because you cannot get punitive damages for defamation unless you show malice by clear and convincing evidence. So I suppose, Justice Cook, I should qualify my yes that malice is going to be an issue both because of the qualified privilege defense asserted and also because there was a punitive award in this case.
Talk to me a little bit about why the statement to Crime Stoppers gives you qualified immunity. I don't understand that.
Yes, Your Honor. The doctrine of qualified privilege, or the defense of qualified privilege, operates either when the speaker has a legitimate social or moral or legal interest in the subject matter of the statement and making the statement, and the recipient has what the court calls a corresponding interest in receiving the statement, or when the speaker has a duty, an obligation, which the court has said can be legal, moral, or social, to make that statement. Here, that is exactly what the facts show. Mr. Pfleger's job was to investigate incidents like shoplifting at Luxottica's store. So he bore a duty to his employer to investigate and do what he could to see that these crimes were solved and thereby prevented.
But Mr. McLeod, does he have a duty to report to an organization, Crime Stoppers, that he knows is going to publish his information even though they might edit it? Is that part of his duty?
Well, Your Honor, I would describe the duty as a bit higher level of generality. The duty he owed to Luxottica was to take action in general to investigate these crimes. And because he had tried to have law enforcement investigate without success. On the suggestion of mall security, where the store was located, he reached out to Crime Stoppers, an organization whose entire purpose is to assist in the solving of crimes when there is not enough information known. And so his duty to Luxottica certainly was broad enough to encompass that. But as I mentioned, he had an interest in seeing the crimes prevented and solved at his employer stores, and Crime Stoppers had a corresponding interest by very nature of its raison d'etre, its reason for existing, to receive and promulgate that information. So
Is there any way to impute malice when he completes the investigation and turns it over to Crime Stoppers, knowing that they are going to publish this? Does that create any imputation of malice by that action at all?
Your Honor, I'm not aware of any principle or even an argument by Mr. Bruce that you can impute malice, if I understand your question, simply because Pfleger knew when he made the statement to Crime Stoppers that Crime Stoppers was going to make it public. We cited cases in our brief that point blank hold organizations like Crime Stoppers have an interest in making public statements. And this court has, as I said earlier, has noted that statements to the general public can be shielded by qualified privilege. That was the Barnett opinion. So I think the short answer is no, Your Honor. There's no imputation of malice simply because Pfleger knew, which he did, that in speaking to Crime Stoppers, they were going to take that statement and publish it further. If there are no further questions by any member of the court, I will yield the balance of my time.
Thank you, Mr. McLeod. Mr. Henley?
May it please the court, Mr. Chief Justice Parker. Good morning. My name is Darren Henley. I represent Jackie Bruce. I want to first thank each of you for this opportunity, for being here, and this opportunity and honor and privilege for representing Mr. Bruce. We're here to ask you to affirm the trial court's order and verdict in its entirety, as it is a just, fair, and legal verdict. There is no reversible error in this matter, and the trial court's verdict is not obviously and palpably wrong, nor did he exceed his discretion in any of the matters. I would first like to address something that's brought up in the brief, but not in oral argument today. The appellants contend that the trial court did not have jurisdiction to enter its Hammond order, and they don't want you to consider that. I think it is of utmost importance for you to consider that order because it addresses and resolves every issue that is raised in this appeal.
But can the Hammond order come after the damages are already awarded? I mean, it seems that's like putting the cart before the horse or vice versa.
What happened, Your Honor, was after the verdict, Luxottica filed a motion for remediature. I responded to that motion for remediature before the hearing, and in it, and this can be found at your record pages 647 and 648, it says the plaintiff requests this honorable court to conduct a Hammond hearing and issue a written order that discusses the green oil factors, and in accordance with the BMW Gore, Hammond, and green oil versus in other cases. So there was a request for that written order before the hearing and before it was decided. Another reason on Luxottica's own motion for remediature triggered the trial court's requirement to issue a written order. This goes back as a generation, as long-standing laws back in '86 when the Hammond case came out, followed by Love versus Johnson. The Court of Civil Appeals was followed, and Tanner versus Appellee, and Guarantee Pest Control. In each one of those cases where the trial court failed to issue a written order explaining why a motion for remediature was denied, the appellate courts remanded it back for just such an order. So we feel like if the court hadn't have issued that order, we would very likely be here on a motion to remand it for just such an order. I also orally reminded the trial court at the hearing of the requirement for him to issue the written order, and Alabama Rule of Civil Procedure 52B allows the trial court to amend its rulings pursuant to a motion filed within 30 days after the judgment. A judgment is defined as any order for which an appeal can be taken. An appeal was taken from the denial of the motion to remit. And
Mr. Henley, let me,
motion was filed
Mr. Henley, let me,
September 7th, which was well within that
counsel,
30 days.
I've got a few questions for you.
Yes, sir.
So I want to understand, first of all, what the key factual issues are here. And Mr. McLeod was up here talking earlier. We've got two different employees of Luxottica. We have the manager, and it seems to me, I'm just going to let you know where my head's at. It seems to me that the manager, as to internal communications within the company, would be covered by McDaniel-Burney rule. Then we've got Mr. Pfleger. It sounds to me like any communications he had on the GroupMe chat, you're not making any claims under that. I looked at your opposition to the notice of supplemental authority, and you make that clear. So it seems to me that we're really just here talking about Mr. Pfleger's communications as to Crime Stoppers. Am I right about that?
Yes, sir.
All right, so walk me through why they're not entitled to prevail under Barnett.
Under concurrent tortfeasor law, what is happening is they're trying to separate the acts of Pfleger and Andrews, but they're co-employees, they're joint tortfeasors, they work together. In fact, there was testimony that Andrews and Pfleger's partnered early on to do what they did. That can be found, the record on page 432. The judge found that they were both acting within the line and scope of other employment. The basic premise of concurrent tortfeasor law is that the injury may have several concurrent causes, including the actions of one or more tortfeasors, neither of whose actions were sufficient in and of themselves to produce the injury, but where they act together, either together or independently to produce the injury, they're both responsible.
Mr. Henley, I looked back at the text of what Mr. Pfleger sent to Crime Stoppers. Crime Stoppers did not publish verbatim what Mr. Pfleger sent to them. They varied it in some ways, right? And if they did, would that not entitle Luxottica to a victory here under Barnett? And that's what I'm asking. That's what I'm struggling with. And so I just need you to walk me through why you think, despite Barnett, you win.
Judge, Your Honor, there was testimony at trial that, and I can cite you to the pages of it, that the only information put on Facebook came from Pfleger. That's on the record, page 337. There was testimony that Pfleger gave Crime Stoppers what he wanted posted, and that's at R340. And Pfleger testified that he gave Crime Stoppers the document that he wanted posted. And that document, it says in there that Jackie Bruce had targeted multiple stores, that he was, along with a ring of criminals, practically, that he had stole $15,000 from just one store alone. All those are false. Absolutely no proof at all of it. In fact, at trial, we asked Pfleger, do you have any verifiable proof at all that these statements you asked Crime Stoppers to put on there, do you have any verifiable proof at all of those? And he said no. And this was after Luxottica had denied that they didn't have any verifiable proof. That shows Luxottica's complicity in the whole thing and a cover-up. So the answer to your question is Andrews and Pfleger combined as joint tortfeasors to create this. We caught both of them in multiple lies during the trial. They made up stuff and put it on the internet. There was no truth to it at all. They didn't even raise the defense of truth. It was just straight lies. And if I may, I'd like to address some of the issues, is that okay, Justice Mitchell?
Yeah, and Mr. Henley, I would like to ask you, like I asked your opposing counsel, about the libel per se argument.
Yes, sir.
And as he pointed out, there was no citation to any authority for that. So if we set aside libel per se, is there anything else that makes qualified immunity irrelevant here?
To answer your question that was posed to Appellant's counsel, the Rips v. Harrington case is still good law. And that case says that where somebody publishes a libelous per se statement and it's not privileged, then it's presumed to be made with malice. It's long-standing law that accusing someone of a felony is per se defamatory. If there's no privilege, the defamatory per statement is presumably done with malice. That's still good law. It's Rips versus Harrington case.
Well, let's focus on the malice part of that. Is there anything you can cite us to in the record that shows malice, or are you just depending on this inference of malice from that case?
No, sir. We proved 11 different ways at trial malice. And of course, malice destroys any privilege they may have. First of all, we contend that we're not even required to prove recklessness because Luxottica admitted it in their answer to the complaint, paragraph 16 on the court's record, page 21, which is the trial court's document, page 9 and page 5, in response to our defamation and false light claim. Luxottica stated in paragraph 16, defendants did act recklessly. But we also, nevertheless, we still presented a lot of evidence on reckless disregard, which is basically failing to determine the statements were founded in false. The court didn't have to infer anything on this matter. As I said, it's absolutely undisputed that the defamatory statements made about Bruce were made without any proof of the truth whatsoever. They had no verifiable evidence that Bruce targeted Sunglass Hut stores and multiple retail stores throughout Alabama. He was sought in connection to multiple felony thefts totaling over $15,000 from just one store. This was all put on Facebook. And the group had been seen in other retail stores committing similar thefts. They couldn't present any verifiable evidence of it because it wasn't true. They can't contend that it was a mistaken belief, a good faith, honest mistake. If they had, they would have retracted it. When I hand delivered a letter to them, giving him Mr. Jackie Bruce's name and a copy of the picture they'd put on the internet and saying this isn't true, they didn't retract it. Common sense tells you that if they had known what they're saying was true, they would have took that letter and that picture down to the police and said, here's your man, his name's Jackie Bruce, go get him. They did not do that. They knew what they said was false.
Mr. Henley, does the fact that the Montgomery police didn't take any action, does that bolster your observation that these things weren't true, that the police know these things weren't true? Is that part of the record?
Absolutely, Your Honor. When it comes to privilege, to the extent that they want to, seek to equate Crime Stoppers with law enforcement. False statements made to the police are a crime, punishable by law. It's not the Crime Stoppers.
So I guess what I'm trying to understand is we know the police didn't take any action.
Yes, sir.
Is there anything in the record that says the reason the police didn't take any action is because they evaluated the statements and couldn't connect them or prove they were accurate?
I think the trial court could infer that there was no probable cause to do it. Now, what happened when you're talking about fabricating evidence? They fabricated evidence to so they could get it on Facebook that Jackie Bruce got in the car with the known thief. This was a complete fabrication.
But as far as you know, the Montgomery Police Department didn't investigate in this. They just chose to take no action. That's what I'm trying to understand. Is that they evaluated it all? Is there anything in the record that the police evaluated and said, we're not going to investigate because it's not true?
There was nobody from the police department testified at trial.
Okay, thank you.
So, but the police have procedures in place to protect the constitutional rights of citizens. Crime Stoppers does not. And it wouldn't be prudent to allow people to put anything they want to on the internet involving a crime, because the police don't want everything on the internet. They like to keep some things confidential. It impedes investigations when you do that sometimes. But anything else on that issue? Okay.
This is Justice Cook. I wanted to ask you the same question that I ask opposing counsel, which is the report to Crime Stoppers. He said that is within the qualified privilege, and he cited us a case that's not a Crime Stoppers case. It's not a social media case, but is one that deals with broader publication to the public. So tell me why the report to Crime Stoppers does not generate the qualified privilege. I understand there's the malice exception to qualified privilege, but tell me why the report to Crime Stoppers is not within the qualified privilege, because that's Pfleger's job to deal with security issues.
Well, the privilege can only go as far as the interest that you're trying to pursue. Luxottica put it on a site called GroupMe, which is limited to retail stores and law enforcement. They satisfy their interest by doing that. There's case law, the Cousins case. Malice can be shown by the extent and mode of your communication. In that case, and the loudness of it. In that case, only 50 people heard it. In this case, thousands of people heard it. So in Cousins' case, malice was shown by the extent of the publication, the loudness of it. Just like in this case. I can't imagine it proclaiming it any louder than put it on the internet where billions of people can see it.
Right, but my question's different. It's not the question of whether you can get beyond qualified privilege. It's whether qualified privilege arises for the defendant at all.
Okay. Of course, they're entitled to raise it, whether you grant it, whether or not the trial court found a privilege or not. Once he finds malice, it's destroyed. So, Crime Stoppers, to argue that they have a common interest with Crime Stoppers to report and prevent crime is a hollow argument. Everybody but criminals has an interest in reporting and preventing crime. So to follow that argument would completely eviscerate the law of defamation per se cases where it involves theft or shoplifting.
And let me go to your punitive damages question. You would agree with me there's no imputation of malice for the purpose of punitive damages because our statute requires clear and convincing evidence of actual malice, correct?
Yes, sir. Yes, sir. The trial court found in his order that malice was proven with clear and convincing evidence. And the trier of fact is finding of malice is particularly within the province of the trier of fact.
But for punitive damages, we're not talking imputing malice there. It has to be actual malice, correct?
Yes, sir. Common law or actual malice is basically this, from what I can determine, is about the same thing. Yes, sir. In a private plaintiff case, there's a, it'd be different in a, well, there's a public figure and you have to show constitutional malice.
Counsel, could I ask you a quick question? Are you essentially saying that Luxottica, through its employees, didn't have enough information to tie, was it Mr. Burke? Bruce, to tie him in with the other individual? And they had little faith in the Montgomery Police Department taking up the investigation. So as a sort of a method of punishing Mr. Bruce, they sent it to Crime Stoppers in an attempt to get it in front of enough people that it would have some effect on him, either through embarrassment or the effect on him in his employment and all of that. That's the only inference that I can see here that is going to get you to intentional, actual malice. And I guess my question is, do you have clear and convincing evidence that the information was more than just incorrect, which we know would not be that would not be a ground for liability here, but that the actual malice can be inferred? What I'd like for you to do is tell me, is there clear and convincing evidence that what Luxottica did was an intent to directly harm Mr. Bruce because they figured they weren't going to be able to go after him legally through law enforcement?
Mr. Henley, your light has come on for the end of your time, but I grant you an extension to continue this exchange with Justice Shaw.
Thank you, Your Honor. That is certainly a reasonable inference because there was testimony at trial from Andrews that Jackie Bruce intimidated him and taunted him and made him think he was about to get robbed. A natural human reaction to that is to respond with ill will and hostility. So,
well, I think I'd like if counsel has time for rebuttal, I'd like for you to address that too, because taking all this down to its bare bones, assuming we have the qualified privilege, the burden would be on you to show by clear and convincing evidence that there was actual malice. And we know it's not just incorrect information, it's actual malice. And I'm trying to figure out why in the world somebody who is an investigative manager at a company would go to such great lengths to try to personally damage someone, as you're suggesting, that would need to exist for the purpose of finding actual malice. And so I'm trying to figure out, you may have an inference, do you have a reasonable inference? And that reasonable inference, I believe, has to be the result of clear and convincing evidence that that was the motivation behind the Luxottica employees. So if I'm hearing you're saying that you think that the record demonstrates that.
yes, sir.
Okay, thank you.
Your time has expired, but you may give us a concluding statement.
Thank you, Your Honor. In conclusion, there's just no reversible error in this case. The trial court is granted the authority to determine whether there's malice. He wrote in his record, it was proven with clear and convincing evidence. I do not think that is clearly and palpably wrong. which would have to be found by this court to reverse it.
Thank you, Mr. Henley.
Thank you, Your Honor.
Clerk, would you add an appropriate amount of time to the rebuttal time that Mr. McLeod has now? Mr. McLeod?
If I may begin, Your Honors, the news is even worse for Mr. Bruce than perhaps he realizes, because not only does he have to show clear and convincing evidence of malice, the standard of review here is not plain and palpable error, as counsel has remarked. We covered this in our brief because the material facts to the elements of the qualified privilege defense are undisputed in the record, because what was actually said to Crime Stoppers is undisputed and in the record. What Crime Stoppers said is undisputed and in the record, because these material facts to the issues appellants rely on are undisputed in the record. The standard of review here, as this court explained in Merchants Bank and many other cases, is de novo. And whether a statement is privileged is, as the court has said many times, a question of law, which is reviewed de novo. So the news is, in fact, worse than perhaps is realized on the burden that actually lay on Mr. Bruce to show malice. Counsel also relied on the findings of fact, and I will just briefly touch on that. We covered this, I think, especially in our reply brief. The trial court's findings of fact are void because they were issued after the trial court lost jurisdiction. The procedural history here is not in doubt. Appellants filed a timely post-judgment motion. It was heard, it was denied, and it was denied within the trial court's 90 days. Once the trial court ruled on all timely filed post-judgment motions, it lost jurisdiction. This court has covered that in Target Media Partners. It said it again in SAI Montgomery, and it specifically said in SAI Montgomery, when a trial court issues an order after it's lost jurisdiction, it is void. There really are no two ways about that. The findings of fact and conclusions of law were issued after the only timely post-judgment motions have been disposed of, and in fact, as I recall, after this appeal had been filed. So they are void and form no part of the court's review. Counsel relied on or made mention of the concurrent tortfeasor doctrine, which is in the briefing. It is not clear to me exactly what Bruce's position is about that, but as we pointed out in briefing, it's hard to have concurrent or joint tortfeasor liability without two tortfeasors. Counsel, or Mr. Bruce, has conceded that privilege applies to Andrews' statement. That's page 180 of the clerk's record. It was an intra-company statement. So if you need privilege, it applied there. But because of the McDaniel-Burney rule, which we briefed and Justice Mitchell mentioned, what Andrews said about Bruce doesn't count as a publication in the first place. The prima facie element of plaintiff's burden of proof as to Andrews was never satisfied because Andrews never published anything or made anything public for false light purposes at all in the first place. So the whole point of the argument about Andrews in the briefing was he isn't a tortfeasor. Plaintiff never satisfied his burden of proof on his prima facie case as to Andrews. So you're down to one tortfeasor and then one company that might be vicariously liable after the fact. So it's mighty hard to affirm a judgment based on the idea of concurrent or joint tortfeasor liability when you've only got one tortfeasor, which is why in my argument I focused on Mr. Pfleger, because his statements are where malice really becomes relevant. And I think that really reaches, I think, Chief Justice, your question. As to Andrews, the court doesn't reach malice at all. You only reach malice if you've got a prima facie case proven and you want punitive damages, or you've got a qualified privilege defense and you're trying to overcome it. That won't happen for Andrews because the plaintiff has conceded below that privilege would apply to his statement, and because of the McDaniel-Burney rule, what Andrews said isn't a publication in the first place. So malice is really only relevant to Pfleger's statement, and that's critical and damning for Bruce's position, because counsel relied momentarily, moments ago, on Andrew's testimony at trial that he felt intimidated when Mr. Bruce, and this is on camera footage, approached him for some moments and came near to him physically. That possibly could be suggestive under other circumstances of a reason for Mr. Andrews to bear malice toward Bruce. There's no evidence that he did. There's just evidence he felt intimidated. But it doesn't matter because that's as to Mr. Andrews. Counsel didn't cite any evidence in the record to give Anthony Pfleger a reason to bear Bruce, who was a perfect stranger to him, an ill will or a hostile intent. It will do plaintiff no good to rely on Andrews' testimony of feeling intimidated to point the finger at Anthony Pfleger as having borne him malice, especially when we bear in mind that the court will look at that evidence through the lens of de novo review and will demand that plaintiff prove malice against Pfleger with clear and convincing evidence, at least, as I say, as to 75% of the judgment here. And even as to the compensatory component, because the privilege defense was interposed and has been asserted here, and I submit proven, the burden lay also on Bruce to show actual common law malice to prevail on any part of the judgment in his favor. So I believe that that will address
Mr. McLeod,
Shaw's question. Yes.
in your view, would we have to reach qualified privilege if Pfleger and Luxottica were entitled to prevail under Barnett?
Well, Your Honor, you've mentioned Barnett several times, as I have. My understanding of the value of Barnett is that it establishes how broadly the qualified privilege defense can reach, or how broad in scope that defense is. And as I say, it has to do with what are the interests being vindicated, what is the duty at stake. And so I think Barnett's value here is how the qualified privilege defense, I think someone has used qualified immunity, qualified privilege is how it's spoken of. The value of Barnett, the meaning of it, the import, is how that defense should and does apply to Pfleger's statement to Crime Stoppers, and for that matter, to Crime Stoppers' publication on its Facebook page.
Counsel, could you, you almost got to my point. Could you address the information that was given by Pfleger to Crime Stoppers? Counsel for Appellee said that it talked about involvement in 15 other incidents of shoplifting over a certain number of stores and all of that. If I understood his, the point he was making, the point that I was trying to get to, ultimately trying to figure out if there is a reasonable inference of malice, because Pfleger was trying to punish him in some way. Could you just address that information? How would Pfleger have known? Did he give that information to Crime Stoppers about other incidents that he would have no personal knowledge of?
Mr. Chief Justice, I see that my time has expired. May I have a moment to address Justice?
Yes, we're at the exact same point that we were with your opposing counsel, Mr. Henley. A pending question from Justice Shaw. Your time has expired, but you may complete the exchange with him.
Thank you, Your Honor. 2 points, Justice Shaw, in answer to your question. First, factually, an emphatic no, and I will direct the court's attention to the first section of argument in Appellant's reply brief, where we cite, I think, every single place in the trial court, in the reporter's record from trial and in the pretrial clerk's record, but mostly, of course, emphasis at trial, to establish that there is not a dispute in the evidence that some parts of what Crime Stoppers posted on Facebook did not come from Anthony Pfleger. Tony Garrett testified at trial that parts of it came from him reaching out to other the retailers. What parts of it? Garrett answered. The part where it says these people targeted other stores. And if you look at the information that Pfleger gave Crime Stoppers, that's in the record as well. You can lay them side by side, and they're appendices to our brief. He does not accuse Mr. Bruce of targeting a chain of retail stores in the area. He certainly does not accuse Mr. Bruce of taking, what's the figure, $15,000, whatever the number was in the Facebook post. And Tony Garrett for Crime Stoppers said, yeah, I got that information from other sources. Anthony Pfleger said, that's right. I didn't give him that. He didn't write that post, and he never saw that post before it was put on Facebook by Crime Stoppers. So that's the factual component. The legal component of the issue, Your Honor, is that, as I said, the privilege defense only operates when a statement cannot be shown to be true. So it does Bruce little good to repeatedly emphasize that something was untrue, because the privilege defense presumes it is not true and operates to shield it from liability so long as bad faith has not been shown.
Thank you.
Thank you, Your Honors.
Well, and Mr. McLeod, like your opposing counsel, I'll grant you time to give us a concluding statement.
Your Honor, I appreciate that courtesy, but truthfully, I believe that I have addressed everything that I meant to today, and will not further occupy the court.
Well, thank you, sir.
Thank you.
And our thanks to counsel from both sides. For you, the law students who are here as summer interns, you heard a lot about common law, the elements of the different claims, and even the standard of review. So all of what you heard today has some impact on what you're studying. We thank you for being here with us today. Our thanks to counsel. And with that, we're going to take the case under advisement, and we stand in adjournment.
All rise. The court is adjourned.